Okay. Good morning. Good
Good
morning.
morning.
How is everyone doing this morning?
Fine, thank you. How are you?
Oh, I'm doing great. Oh, it's always such a pleasure when you guys turn on your cameras. Thank you so much. So, um, all right. So let me okay. Right, there's one person who had entered with just their initials on their display name, but they fixed it. So I appreciate that. So thank you for taking care of that so I don't have to message you. Um, okay. So let's start by just checking in and see how things are going. So um, there's two pieces to this, right? The first one is I want to know what you feel like you learned in last week's lecture. Um, and that's just a check in to make sure that what I think I'm teaching is what you're learning. And then the second piece of this is if there's anything that you're not clear on, anything that's still confusing for you, this is your opportunity to ask. Okay?
Okay, so
Yeah.
last week we learned about causation and the but-for test, which means
Mhm,
that had it not been for the defendant's actions, the harm would not have occurred.
mhm.
We learned that there are exceptions to this, like the intervening causes, which can be by a third party or the plaintiff himself, and this could possibly cause the original defendant to be absolved from liability.
Mhm.
There were also exceptions to the intervening cause doctrine. Therefore, I don't know if you want me to expand. And the superseding
This is
causes.
this is just a quick review, so we don't need to go too far down the rabbit hole.
Okay. Well, I did have a question when we talked about the psychiatric injury and economic liability. I wanted to know if, because you said that only someone with a relationship that if they witness the accident or if in some cases the immediate aftermath, if like that doesn't apply to bystanders at all, so they have no claim at all.
Yep, that's my understanding. So what do you
I
was
was
that the
just sorry.
question or was there was there more to
If
it?
that
Sorry.
was just the question, if
Okay.
bystanders who witnessed the accident, if yeah.
Yeah. No, the idea is that um this is the secondary victim doctrine. So the idea is that you, the plaintiff, have no physical injury, but you are making a claim based on the harm you experienced from witnessing someone else's physical injury. And the idea behind that is that um, you know the trauma that's associated um, with someone else's harm is really only cognizable if they were someone you cared about, right? So we know, right, if you've done any work taking any psychology courses, we know that certainly just like witnessing other people's injuries can be a source of trauma, but the law does not recognize it as a recoverable injury. Okay. So does that answer your question, Shasya?
Yes, it is. Thank you.
Great. Okay. Anybody else have any questions? Anything that you are not quite clear on? Um,
Sir,
Preferably from. Go ahead, Pamela.
sir, when you said recoverable injury, you mean that the person will not be compensated, right?
Right.
Okay, cool.
So yeah, no, there's no liability in tort for the for psychiatric injury um, related to uh, a bystander. Right. There's no relationship with with the secondary victim. Okay. Yep. Absolutely correct. Okay. Um, all right. What other questions? Anything else? It's okay if there's not. I'll give you guys a second to think about it. Okay. So moving on. So today's activity is, as we've discussed a couple of times, right? We do these check-ins. These are 1 week look backs. And then the activity for the tutorial is a 2-week look back. So we're going back to the breach analysis. And the task that you were asked to prepare, I'm going to put it into the chat. The task was to write a fact pattern that, if true, would give rise to an inference of res ipsa loquitur. And this fact pattern should not match any case that you've read, either in this course or elsewhere, because the point of this exercise is to think about what sorts of events are impossible in the absence of negligence. Okay, so the activity that we're going to do is what, if you have done any work in the education realm, this is what's called a think, pair, share activity. And if you had done no prep work, I would now give you guys a few minutes to work on your own to come up with a response to the prompt. But since you did that before you came in, as I asked, we're going to go straight on to the pair. So we're going to put you guys in breakout rooms with at most 2 other people, but very likely only 1 other person. Actually, there's an even number of you, so it'll all just be pairs. And what you're going to do is you're going to explain your fact pattern to your partner. And then when we reconvene in about 10 minutes, you're going to present your partner's fact pattern, not yours. And I want to explain to you why we're doing this, right? There's a specific pedagogical purpose that this serves. And there's 2 things that we're trying to accomplish here. The first is we're trying to give you some practice in taking someone else's story, writing and explaining it in your own words. So this is a piece of that puzzle. The second piece of it is that sometimes it can be a little nerve-wracking for folks to present their own ideas, particularly in an environment where those ideas are then going to be picked apart and criticized somewhat. By presenting someone else's ideas, that lowers the stakes for everyone, right? The presenter is able to sort of not worry about it because it's not their idea that they're presenting, and the author is able to, at least what I find myself doing in these situations is I'm able to sort of go, oh God, no one's looking at me. Please don't look at me. This isn't real. This isn't happening. And I don't have to think about the class. So this is why we're structuring it this way. Do you have any questions about what you guys are going to be doing?
No, we're just telling the other person what our fact pattern is, right?
Yep. And if things happened and you didn't have one, you don't have one prepped, then this is your opportunity. You can take the time to work with your partner and try and come up with something. So if you need to sort of do a quick think while you're doing your pair, you're welcome to do that as well. Okay. So with that, I'm going to put you guys in the breakout rooms, and we had a latecomer. And so with that, we're going to put you guys in. If you are Erica's partner, and Erica, I don't mean to call you out with this, but you just came in. So rather than try and explain explain this again. If you are Erica's partner, please explain to her what we're going to be doing in the breakout rooms, and I appreciate that of whoever it is. And the rooms are open, so please go on in. And we'll reconvene in about 10 minutes. Tasma, are you okay? Hello? We are back on the record. And as you guys are aware, right, I'm always happy to call on folks if I need to, but I would much prefer volunteers, right? So who would like to go first? And going first is hard, so.
Pamela and Kayla will go first.
I'm sorry, go ahead, Pamela.
Right. Kayla
Yeah.
was my partner. And what Kay came up with was that Kay bought a wedding dress online from a place that they actually made these dresses themselves. Mm-hmm. And when she got it, she realized that the zipper part was not stitched properly, so it was malfunctioning. With all the thread, like it wasn't stitched properly, basically. So she called them. She called them, and they said basically that it's not their fault, that everything was intact before they shipped it and everything. But clearly, we're saying that from shipping to the time she received it, it had to be their fault. The fact speaks for itself, because the stitching wasn't properly sewn.
So is there more to this, or is this the story?
That's it, basically.
Okay, so I think that this is really helpful. And first of all, thank you for going first. And you said, I'm sorry, was this Tia's presentation?
Yeah.
Tia's fact pattern. Okay, so I appreciate this on both ends, both what you were able to, the creativity of it, and also the analysis that you've provided. I think that you're on the right track in that, you know, res ipsa is about the situation where we can't prove what the negligent act is. So you're right, that we're convinced that there's something wrong here. The thing that I'm skeptical of in terms of applying res ipsa in this particular case is that I'm not convinced that we can't identify the negligent act, right? So it sounds like from what you're saying that the negligence is an issue with the sewing, right? That the stitching was done improperly. Mm-hmm. If we can identify what it was that caused the harm, then res ipsa doesn't apply. Okay, so res ipsa is the specific situation where the plaintiff cannot prove the negligent act that occurred, right? And ordinarily, right, if the plaintiff can't prove that a particular negligent act occurred, they lose. But if they can show that there is no non-negligent for the accident, then res ipsa comes into play. Okay. So I think that you've got the right idea that we're for the facts speaking for themselves, right? That's what res ipsa loquitur means. But if we can identify the negligent act, then res ipsa wouldn't apply because it's not necessary. Okay. So, but great job. I really appreciate going first, right? Going first is always scary. So now that you guys have seen how this is going to work, who would like to go next?
I thought Tia was going next. Sir.
Yeah, I thought I was.
Okay, Tia, you're welcome to go next. Yeah, that's perfectly
Okay.
fine. You are not required to like go with your partner. You guys can break this up as you see fit, but Tia, you're more than welcome to go next.
Okay. Pamela said the plaintiff hired a landscaper to
Tia, are you there? You look like you've frozen.
after.
So
Yeah,
the last thing that I heard was that the
Hello?
plaintiff had hired a landscaper.
Yes, to install some faucet in the plaintiff's house. And a couple of days they told her to put the faucet on low before she used it, and she did that. She left for a couple moments after, and when she returned, she saw there was flooding in her house, and she found the source of the flooding was from the faucet. And the defendant said that you can't prove that that's because of my negligence, that I was negligent in any way. And but the receptor would come in and say the fact speaks for itself, that from you see that the faucets, all the water is coming from the faucet, that you see that that's the cause of the flooding, and he was therefore negligent.
Yeah. So I think that's this is an interesting fact pattern, because I certainly agree with you that like there is room for a res ipsa argument in this situation. I'm not convinced that it's necessary for some of the same reasons that we talked about with Pamela's presentation, in that you know, we can point to, this is the negligent act here. It's the installation of the faucet. In fact, it's very likely that when the second handyman or landscaper comes in to repair the issue, that they're going to be able to identify what exactly was done negligently, because it's going to be the thing that they have to fix. So I think that in that circumstance, we still have a situation where we know what the negligent act was. If we wanted res ipsa to apply, what we might argue is that instead of just going away for a moment or two, that the plaintiff leaves for a month, and when they come back, the house is flooded and ruined, and the only thing that could have failed is the faucet, right? So there's no wear and tear argument here. So I don't know that this is that necessarily works very well, but I think it gets closer. So does this make sense? Kind of where we are on this?
Yes, sir.
Okay, great.
I have a question. I'm
Of course.
a little confused. The res ipsa only happens when you can't prove that the act was negligent, or
When you can't prove what the negligent act was.
but I thought the whole doctrine says that the facts speak for itself, and
Right.
that
And if you can prove what the negligent act was, you don't need the facts to speak for themselves, because what happens, the way res ipsa works, is it's a burden shifting framework. The plaintiff says, look, there is no non-negligent explanation for this. And if the court accepts that, right, the defendant has the burden of then showing that they met the duty of care. Okay, so for example, right, and I apologize if I'm stealing someone's thunder that you wrote a fact pattern similar to this, but some of your classmates have come up with fact patterns involving people who are injured riding roller coasters. Okay, and they point out that there's not really a reasonable explanation for why a roller coaster car would fly off the tracks, except for negligence. Okay, but if the defendant can come in and say, look, we met all the regulatory inspection requirements, we did all the recommended maintenance, we did everything that we could reasonably do, and some act of God intervened and snapped off this bolt, then that would rebut the presumption that res ipsa creates. Tia, does that help? Does that help you, the doctrine, make a little more sense now? Like why it operates the way that it operates?
Sir, now you've mentioned the roller coaster, I think I now understand what you're saying, because obviously you would expect some kind of recklessness or negligence if you go on a roller coaster. So
Right.
it obviously would be more difficult to prove there than it would be if somebody was just walking down the street and fell on a banana peel.
Right, exactly.
So I got you covered. Yeah.
So Zania, you had your hand raised, and then
Yes,
Shasia,
sir.
yeah, go
I
ahead.
just wanted to ask, so then who would the negligence be toward? Who would have been negligent in this case?
In the roller coaster case, or in the
In general, because like I was assuming that res is so locator, the facts speak for themselves, means that the negligence is clear. But now you're explaining it is that you can't see the negligence, or that no one was really
Yep.
negligent. So then where does the whole topic
Yep.
of negligence thing? Is this just something that just happened with?
So this is not, despite Justice Cardozo's best efforts, this is not a case of negligence hanging in the air. So what is happening with res ipsa is that as part of the proof of proving a tort claim, the plaintiff has to be able to point to a specific act that the defendant did that was negligent. The problem is sometimes you don't know, right? And under the normal course of the of proof, if the plaintiff doesn't know what it is the defendant did that was negligent, they lose. Okay? But this is an exception. Res ipsa is an exception to that rule, where if there is no reasonable explanation, then you can put the burden on the defendant to offer one. Okay, so the defendant now has the burden of proof to show that they were not negligent. All right, so think about the case, right? You remember I told you guys that when I was taught torts, res ipsa was taught using a case involving a church bell that ran someone over in the street, right? And the court observed that in the absence of negligence, church bells generally don't go on road trips, right? If the defendant had come along and said, in fact, right, we were rolling the church bell from point A to point B, and this is the normal way in which church bells are transported. Do I think that's a terribly likely story? No, but if that was the story they told and the court credited it, then the defendant would not be held liable, because negligence doesn't require you to make every effort to prevent harm. It only requires you to make reasonable efforts. And so if the defendant has made every reasonable effort and the harm occurs anyway, that's just the way the universe works. So, Zinnia, does that help?
Yes, it does.
Would you
And
tell
one more
me?
question.
Would you tell me if it didn't?
Yeah.
Okay. So sometimes I worry because I explain things and students go, "Oh yeah, that makes perfect sense." And the fact that it always works worries me sometimes. So, but go ahead. You said you had another question.
So if the so in the case of the roller coaster, if the persons responsible for these roller coasters can't prove that they were negligent, would they have to accept liability?
If they can't prove that they weren't negligent, they would have to accept liability. That's how res ipsa works, right? If you successfully invoke res ipsa, the plaintiff has proven their case, and it now becomes the burden of the defendant to disprove it.
Okay,
So does
understood.
that answer your question?
Yes, thank you.
Shasia, you've been very patient. I've noticed your hand has been up. Go ahead. What was your question?
This is just to inform you that clearly they understand res ipsa loquitur. I've been frantically trying to come up with another fact pattern, because so from what I'm understanding, the defendant would have had to have some duty, and they would have needed to, they breached that, and they would have had to have done some negligent act involved in the thing to be liable. And it seems to deal with mostly, like, I don't know, companies or something, because I can't think of a situation where, like, I understand it now, but I can't think of a fact pattern now.
So a fact pattern that doesn't have to involve a company, right, is think about a car wreck, right? If you rear end another car on the highway, okay, there's absolutely non-negligent explanations of that car wreck, right? Conditions can be such, that the physics of the vehicles just does not lend itself to preventing the collision. But if you hop the curb and you run over a pedestrian in the sidewalk, that's probably res ipsa, because normal non-negligent operation of a car does not put you on the sidewalk. Okay, except maybe in Barbados, where apparently people park anywhere they want. Sorry, I shouldn't let my own bitterness about driving here color how I teach. But does that maybe make it a little clearer now?
Yes, but if the person mounted the sidewalk, clearly they did something. You could see that well, I guess you can't prove exactly what they did or what caused them to do it. So, but the fact that they ended up on the sidewalk means something negligent happened.
Exactly. Whereas we can come up with reasonable non-negligent explanations for why you rear end the car in front of you, right? Including even the possibility that you were yourself rear-ended, right? We could transfer liability further back in the queue. So, so does that help, Shasia? Do you feel better now?
Yes.
Okay,
much.
great. Shikari, your hand is raised. Go ahead.
Okay, sir. I just wanted to read my partners so we could understand if this is in the right direction.
Sure. Who were you working with?
I was working with Barry.
Okay, so go ahead.
Okay, so Adrian Ramblin was married and had 6 children. Throughout his marriage, his wife often scolded him for watching sports before spending more time with his children, especially their last child, who was their only daughter. Adrian often argued that while it is important for fathers to spend time with their daughters, he has bonded more closely with his sons, and since this is their only girl child, his wife would take the lead. But she disagreed, and on several occasions, she asked him to at least spend a day with his daughter and bond with her. After all, she was only 18 months, and it would have been a great paternal initiative. Adrian was also an avid baseball fan who loved the Red Sox and never missed a game. His wife hated baseball. One day, she asked him to take their daughter with him to spend a day, and it so happened that the Red Sox were playing the Yankees. Adrian had one ticket and decided to take his daughter, who wouldn't need admission because she was an infant, and leave the boys home because he wouldn't want to seem that he was parenting one of them. So he and his daughter went off to Fenway Park. Unfortunately, though, the Red Sox loses, and Adrian leaves very angry. He went to the car, safely straps his daughter in the back of the vehicle and in the designated Red Sox fan area, where he sees some of his buddies. They start reviewing the game, and he gets caught up in a discussion about why the Yankees won. Over 45 minutes pass, and Dave forgets his daughter in the backseat. He suddenly remembers she is unconscious, having little oxygen to survive the heat in the car. As paramedics comes, she dies, as it was too late for her to be revived. Was Adrian guilty of manslaughter brought on by negligence?
Wow. Okay. So there's a lot here. If I apologize, I apologize to anyone who was distressed over that. No actual children were harmed in the writing of that fact pattern. But the issue that I see is, again, right, where we keep coming back to that we can identify the negligent act here. And so I'm not convinced that res ipsa applies. I think it's very clearly negligence, but I don't think there's a res ipsa issue. So one thing that might, so maybe instead of the harm coming about through leaving the child in the vehicle, maybe it comes about because the brakes on the vehicle fail, right? And it rolls away from the father and into traffic, and the car is struck, and et cetera, et cetera. That might be a situation where res ipsa comes into play, because then, we're not sure if you left the parking brake off. We're not sure if the defendant, if there's an equipment failure, a failure of maintenance, right? But there's clearly something that has happened, because cars don't normally roll away from their drivers with no one in the driver's seat. So that's what I would say, how we might change this so that it would actually be a res ipsa fact pattern. Okay. Wow, the time has definitely passed quickly. Have a private question. Would it be something like a state of affairs? Have you been reading Edmund Husserl? Because I'm reading a book about the philosophy of mathematics, and the term state of affairs is very important in this book. So I'm curious if you're in the same boat that I am. I think the answer to your question is the state of affairs is sort of what we are looking at, right? Is this a situation where there's no explanation that is non-negligent? Okay. Another question in the chat, a private question in the chat. isn't hot car deaths a thing already, and that's what the individual would be charged with for leaving the child in the car? Absolutely, but this is not a criminal law class. We're talking about torts, and specifically we're talking about res ipsa. So we're trying to devise fact patterns that would give rise to that. Erica, you can have the last word. You've been very patient and I appreciate it. So go ahead.
Sir, I just want to read my scenario to you to see if you're following as well.
Okay. And before you get into that, let me just say that if you have not had a chance to offer up your scenario and you would like me to advise you on whether you've met the requirements of the doctrine, you're welcome to email it to me. Okay, so I've done that for several students. So go ahead, Erica.
All right, sir, a passenger on a flight was on his way to the bathroom when the door on the plane was suddenly opened and the passenger walking by was sucked into the air, which resulted in his death. The engineers were held liable for the malfunctioning of the door and thus resulting in res ipsa locator.
That certainly sounds, you broke up a little there right at the end, but it what I heard sounds like res ipsa to me, right? Because airplane doors don't just open, right? Something has to have happened. Now, the as we discussed, right, the defendant has the opportunity to rebut the operation of res ipsa. Again, right, if they can show that they did all the reasonable things that could be done to prevent the accident, then they would not be held liable. But I think that you're absolutely right that we can't identify the specific thing that led to the door opening, but we know that something happened. Okay. Giuseppe, we're out of time, but
I just
you
have a
can go
comment
ahead.
on the
Yeah.
thing that you said. I just want to comment on it.
Yeah, no, absolutely.
Wouldn't the engineers or the persons on the airplane who's supposed to ensure upkeep of the airplane be liable and prove negligence? And furthermore, if airplane door open if the door opens on the airplane, everybody would be sucked out because everybody would be like, I don't understand. I'm really not.
Well, okay.
Down in seatbelt.
Yeah. So
Okay.
Yeah, this is why they tell you that even if the seatbelt sign isn't lit on the airplane, to keep your seatbelt on when you're in your seat, because it's about risk management. It's saying, okay, if you have to move around the cabin, then, in the unlikely event that the door flies off, sucks for you. But if you're not moving around, if that happens, you still survive because you're belted into your seat. But the issue for proving the normal course of negligence is that you're not able, under this scenario, we're not able to identify the specific negligent act, right? Because it could have been a failure of maintenance, right? Maybe the bolt that holds the door closed was wearing out and the engineer didn't spot it. Or it could be an operator error, right? The flight attendant who closes the door doesn't close it properly, right? And you can't really tell the difference between those two situations, but you know that one of them happened. So does that make things a little clearer for you? Okay, guys, we are out of time. So I really appreciate, I really like this activity because I really appreciate the creativity that goes into creating the fact patterns. And so I appreciate the work that you guys put into that and the work that you put
So
in
can I just
today.
say that I found that since we did the fact pattern and you explained it, some of us were wrong, we didn't get it right. We not understand it. If we can do another one next week on something else, perhaps that would help.
We're gonna continue doing these kinds of activities. This is going to be, we're not going to be doing something like this every week, but we will be, like, that's the point of tutorials, is to give us an exercise that helps to clarify something that we've talked about in lectures. Okay. I have a private question. Can we do these with almost every topic? Not necessarily with every topic, but certainly if there are things that I can come up with where this is workable, we'll be doing things like this. Okay. So, all right, guys. Unfortunately I can't hold over because I have another class immediately after this one. But I will see you guys next week. So take care and bye.